everybody. My name is Oliver Westmoreland. I'm an OISC Level 3 Registered Advisor of the GSN Immigration. Please subscribe to our YouTube channel and click on the bell icon so you continue to watch our extremely interesting videos about UK visa and immigration advice. Today, my video is going to be about British nationality and the good character requirement. Now, I'm sure you know there are various substantive requirements that have to be met if you're going to make a strong application for British registration or British naturalisation. There is another particular aspect of requirements which is called the good character requirement. If you have good character, you're fine. If you don't have good character, you might not be. And like everything else, there are complex rules about it. The obvious thing most people probably know about already, if you have a conviction and a prison sentence, this could, destroy your application. If you have a prison sentence of 4 years or more, your application is going to be refused. Always, anytime, you've had it, you've got no chance. If you've had a prison sentence of at least 12 months and up to 4 years, your British citizenship application might be successful, but only if 15 years have passed since the date of conviction. If you have a prison sentence of less than 12 months, your application could be successful if 10 years have passed since the date of conviction. And this one, most of our clients, they don't have criminal convictions, I'm pleased to say, but this is the one that comes up quite frequently. If you have any sort of criminal sanction, your application is going to be refused unless it was at least 3 years ago. Now, any sort of criminal sanction, this covers a lot. A fine from a court is, as far as the Home Office is concerned, it's a criminal conviction. A caution or a reprimand from the police is deemed to be a criminal conviction. Fixed penalty notice is not, but the other ones are. So if you've got one of those on your record and it's less than 3 years old, it looks very much as though your British citizenship application is going to be refused. And if you're in that sort of situation, we strongly advise that you don't make the application, excuse me, because your fee is going to be wasted. These are mandatory rules. They're not discretionary rules, pretty much. Almost certainly your application is going to be refused if you fall foul of these criminality rules. So you need to get good and proper advice about this. Sometimes there's a bit of a debate as to whether something is a criminal conviction or not. If you need advice about that, contact your good lawyer who can give you the answer, because you need to know this before you make the application. Another thing that comes up connected, some people submit an application and for whatever reason they don't declare a criminal conviction. If that happens, you might get refused because you've got a criminal conviction and because you allegedly exercised deception in not disclosing the criminal conviction. So this is what's called the double whammy. That's another thing that you've got to be careful about. Other things are not criminal convictions. Bankruptcy order is not a criminal conviction. CCJ, County Court Judgment, is not a criminal conviction. These sort of things wouldn't normally or typically result in refusal, but they might if they're severe enough. If you've got 10 CCJs on your record over the last 5 years, it could be. If you've been involved in a bankruptcy matter and it's been alleged that you have committed fraud in connection with that, that could be sufficiently serious matter for your British citizenship application to be refused. You need to get good advice on that. Finally, it's not only criminal convictions and things. If you've been in breach of immigration rules, in the last 10-year period, I'll say that again, in the last 10-year period, you've been in breach of immigration rules, you might find that your application is refused. Now, this was a rule that was introduced, I think, sometime last year or maybe the year before. You probably know that the basic qualifying period for British citizenship is 5 years, or in some cases 3 years. Home Office introduced, I wouldn't call it a law, I would call it a policy, but it's obviously a legally effective policy. Home Office introduced a new policy. Any transgressions within the last 10 years could result in your application being refused. If you read the rule or the policy carefully, it seems to say that if you have any overstaying in the last 10 years, that could cause your application to be refused. Now, there are a few mitigating potential mitigating circumstances. But pretty much, if you've got any overstaying in the last 10 years, that could make your application be refused. You need to get good advice about this as well. Finally, this is a funny subject, illegal entry. Now, if you're a normal illegal entry, if there's such a thing, if you've illegally entered the UK in the last 10 years, whatever else has happened since then, probably you're going to find that your application is refused. If you're an illegal entrant who subsequently claimed asylum and your asylum claim was successful, you might or might not find that your application is refused if that illegal entry was in the last 10 years, even if you were granted asylum. There are some fairly complex policies about this. So again, this is something that you need to get really good and accurate advice about from your lawyer.
Thank you very much, Oliver, for going in depth and explaining about the good character requirement for applications to settle and live in the UK permanently. Often people find themselves in the situations that they later may not be very happy about.
You're right there.
And it might be worth talking about some of those scenarios to give some more clarity to the viewers. So, for example, if someone during the COVID period may have received fine from police about breaching COVID rules, perhaps, can that affect their application?
I don't think it would necessarily be a fine. I think it's more likely to be a fixed penalty notice. Fixed penalty notice does not make a criminal record.
Okay.
Now, if someone has actually received a fine from a court, then that's a criminal. That creates a criminal record.
Mm-hmm. All right. And some people find themselves, having points on their driving license, perhaps due to overspeeding, and may have to do a course to about the overspeeding issues. Can that also impact negatively their application?
Well, if it's part of a criminal conviction from a court of law, yes, it can. I mean, the test is quite simple. If it's a criminal conviction that comes from a court of law, a Crown Court or a magistrate's court, then it's a criminal conviction.
Sure. You may recall some students, international students, were taken off their visas, and even some of them were deported.
I think they were removed, actually.
Removed, exactly, due to the English language test called TOEIC. And Home Office said that they believed the tests were not taken honestly, and they wanted to revoke their visas and remove them from the UK. Any person who may have gone through that situation, should they be worried about their settlement application?
Yeah, or indeed British Nationalisation application. Yeah, I think perhaps they should be worried about it. The way that it works, if the Home Office makes a finding of dishonesty, that finding stays on the record unless perhaps it's overturned at an appeal or judicial review. So I would say if the Home Office has made a finding of deception, which may or may not be true, we don't know, different cases are different. We know that some of these TOEIC cases, in fact, it was not shown that the migrant had exercised deception and dishonesty. But if the Home Office has made such a finding and that finding has not been challenged, I think that would be a finding of deception that could cause the application to be refused, I would say.
Sure. And going back to some of the information you mentioned in the vlog about the length of the sentence and how long that person cannot apply for British citizenship. I mean, they can apply, but it will not be granted.
Yeah.
If that time period, if someone already holds ILR,
yes,
and they're not being successful with their British citizenship application because of the sentence that they may have gone through, does that mean the Home Office may also try to remove their ILR, or they can stick with the ILR until they become eligible to apply for naturalisation?
I suppose the Home Office could try and remove someone's settlement status. Unfortunately, there's no right of appeal against this. The only remedy is judicial review. I mean, that's a different subject, really, because if your settlement status is revoked, then you've got no way that you can apply for British citizenship anyway. It's a possibility. But let's say that your settlement status was not revoked, you're still going to come up against those time periods. If the sentence is between 12 months and 4 years, whatever else happens, you're still going to come up against that 15-year rule, or the 10-year rule if it's less than 12 months.
Okay. And in these sort of situations, some people may have British children going to schools in the UK, or may have a medical condition that needs proper treatment, regular treatment from the NHS. And the children, they're under 18, they need their parents with them to go by, do everything. Now, how would that fit in with this sort of situation where Home Office may want to remove this person, but they may have British children?
We're going into a slightly different area here. If you have British children and British parents, you're talking about a situation where the Home Office is thinking of revoking British citizenship, possibly, aren't you?
Yes.
Because if that happens, I do know of cases, real life cases. What might happen in a situation like that is that the British citizenship is revoked. Now, there is the right to appeal to the first tier tribunal for that. But if the migrant is ultimately unsuccessful, what might happen if there are children in the picture, because when you have children in the picture, of course, the picture changes dramatically, the Home Office might grant limited leave to the parent whose British citizenship has been revoked, because they can't offend the rights of the children to that sort of extent. If there's no children in the picture, then the person's situation is more difficult.
Sure. Because we do come across some clients who do have indefinite leave to remain, and without having any issues with the good character requirement or any other requirement, they choose not to apply for British citizenship because the home country where they may have come from does not allow dual citizenship.
Yeah.
And this could be some useful information for them.
This is a different issue as well. If you want to keep the nationality of your country of origin, and you want British citizenship, but your country of origin does not allow multiple citizenship, you can't apply for British citizenship because, you can, but if it was ever discovered that you had acquired British citizenship and the laws in your country don't allow it, I think you're in a very bad situation. I wouldn't recommend that anyone tries that. Now, some people apply to revoke their British citizenship of their own volition. That's a big step to do, but you can do it. Let's say, for example, you want to obtain the nationality of country X and you hold British citizenship. Let's say the laws in country X say you can't hold multiple nationality. You'd have no choice, if you're going to do things legally, which we would always recommend, you would have no choice other than to renounce your British citizenship so you could get the citizenship of country X.
Sure. Great. Thank you very much for today's vlog, and we look forward to seeing you in the next one.
Yes, thank you very much indeed.
Bye.
Bye-bye.